It's 1-800-LAW-1010, 1-800-LAW-1010.com. Paul Harding on the phone. Hey, Paul.
Good morning, guys.
We were talking about this earlier in the show. I don't fully get it, and I know you had a chance to look at it, but cops can force you to unlock your phone with the Apple Touch. They can't make you. They can't ask you. You don't have to give them your password, but they can make you put your finger on the screen. Is that what this is?
Yeah, I'm not sure I get it either. I mean, that's what the court came down. It was a Virginia court that came down and said that. But let's back it up a little bit. Most recently, about 8 months ago, the Supreme Court came down and said, hey, you cannot go through someone's phone. The police just can't kind of pull you over. A lawful arrest is occurring, and they can't start rifling through your phone. That does require there to be a warrant to go through that. So that's kind of new, because I think we even had a story on this where someone had a picture on their phone, and cops were able to find that.
Right.
So that rule changed. But now this is sort of amazing. They're saying, well, yeah, if we do compel you to give us your phone, we can now compel you to put your finger on the encrypted code to get to the phone, but we still can't compel you to give us your 4-digit code or your encrypted actual numeric code. So I'm with you. This is confusing.
So the fingerprint would be considered some kind of DNA evidence or physical evidence that can be...
Yeah. Over the years, they've said that they can take blood samples and hair samples and DNA. So they're saying, look, at the fingerprint's sort of like the DNA. We can make you put your finger on your phone to open up your phone and give us all the contents. So, yeah, that's the rule. I think this is a classic case of technology moving faster than the law.
Right.
We'll see where this case goes. But, again, it was a Virginia case, but it was one that got everybody's attention.
Paul, we have a listener who I'm not going to mention who had a very a scary situation, including that the unlock the touch, where he was threatening, telling his girlfriend that he was going to kill himself. This is a listener's son. He was going to kill himself. Texted her. She called the police, and the police came over to look at the phone and said, "Hey, can you unlock your phone? We need to see if you were really threatening to hurt yourself." And he didn't. He didn't let him unlock the phone. And then, so they arrested him and took him down to the hospital
for his own well-being.
For his own well-being, yeah, which I think they have to do. And then they let him out after 3 hours, and he went home and did it anyways. But it's like there's a buffer right there.
Yeah.
That is, on the other side of the story, it's maybe saving somebody's life. I don't know. Had they been able to do that, would they have seen that and had the proof that this kid was seriously in jeopardy?
And have the ability to keep him in the hospital longer until potentially whatever episode he was going through, whether it was chemical or emotional, could have passed. Yeah,
right.
Yeah. So real life stuff, real life example of where this stuff is significant. We read about it, and I think people can kind of throw their hands up and say, "Wait a second, I don't understand. They can make me put my finger to unlock my code. I don't have to give them my numeric code." But these are real life examples of when there can be, in this case, life or death consequences. So. Yeah, I think that if they had more information, that they're likely that they would have held them longer at the hospital.
Paul Harding from Martin Harding and Mazzotti, 1-800-LAW-1010 and 1-800-LAW-1010.com. Thanks for the time, Paul.
Okay, guys, great stuff. See ya.
Quinn and Cantera.
No! In the face! In the face! No!
Mornings on PYX 106.